Good morning from the Freedom of Information and Privacy Association. I'm Patrick Farnsworth. This is your Access and Privacy Online News Summary for Saturday, July 11th. We are back after a brief holiday break. This week, a lawsuit over the exposure of nearly 3 million Alberta voters, unanswered questions about overdoses inside BC hospitals, expanding surveillance in the United States, and a serious threat to Germany's freedom of information law. Let's dive in. First, we just really want to thank everyone who signed House of Commons petition E7237, calling for enforceable privacy protections and independent oversight of federal political parties. The petition has now closed with more than 9,000 online signatures. That support matters, but the work is not finished. Contact your member of parliament and keep asking political parties and candidates what information they hold about you, where it came from, how it is used, and whether you can correct or delete it. The Voter Privacy Coalition is also encouraging people to continue collecting paper signatures over the summer. Completed sheets should be returned by September 2nd so they can be delivered for tabling in the House of Commons. The central message remains simple. Personal information should not lose legal protection merely because it is being used for political purposes. The consequences of weak voter data safeguards are moving into court. A proposed class action has been filed over the exposure of the personal information of nearly 2.9 million Albertans through a database linked to the Centurion Project. The claim names the Alberta government, Elections Alberta, the Republican Party of Alberta, and project leader David Parker. It alleges failures to protect the voter list and says the breach created risks of profiling, targeting, harassment, and loss of control over personal information. The claim also alleges that Parker should have known that his use of the province's official voter list would put Albertans in harm's way. A spokesperson for Justice Minister Mickey Amery said the province is reviewing the statement of claim and takes the security of Albertans' private information seriously. The allegations have not been proven, and the case must still be certified before it can proceed. Meanwhile, in other network news, the International Civil Liberties Monitoring Group marked the United Nations International Day in support of victims of torture by urging the federal government to act in 3 cases. The group is calling on Public Safety Minister Gary Anandasangri to end deportation proceedings against Mohammed Hakrat, including the recent decision from a federal court justice supporting Hakrat to stay in Canada, on Foreign Affairs Minister Anita Anand to repatriate Canadians detained in northeast Syria and Iraq, and on Justice Minister Sean Fraser to provide accountability in the Abu Sufyan Abdelrazak case. Enclosed in the letter to Minister Anand is a call from the UN Human Rights Committee for Canada to repatriate all its citizens from northeast Syria and Iraq, and a recent report from Human Rights Watch that warns about unfair trials, torture, and the common use of death penalty in Iraq. The group says Canada must not expose people to torture, arbitrary detention, or unfair proceedings abroad. Now to stories informed by and about access across Canada. We begin in Ontario, where LGI reporter Daryl Knight at the Standard newspaper reports that Durham Regional Police highlighted new officers, higher spending, and an online community safety portal during an update to Brock Township Council. The portal gives residents access to crime statistics, safety data, budgets, policies, agendas, and live-streamed meetings. The website is part of its 2024 to 2027 strategic plan, which emphasizes modern policing, stronger community partnerships, and building public trust through greater transparency and accountability. The important access point is that public confidence depends not only on police resources, but on residents being able to see how priorities are set, which outcomes are measured, and how public money is used. Also in Ontario, a coroner's review has made 28 recommendations to improve mental health support for correctional workers. The report found growing pressure within an overcrowded jail system and called for better benefits, peer support, training, and recognition of correctional employees as public safety workers. The report, titled In the Light of Day, also found that 34 correctional workers have died by suicide over the past 15 years. The report reviewed death investigations and spoke to more than 90 people to make the recommendations. Freedom of Information records obtained by the Canadian Press showed Ontario jails operated at an average of 127% capacity in 2025. That data connects workplace harm to a broader transparency question: whether governments are publicly measuring and addressing the conditions inside correctional institutions. Turning to Alberta, LGI reporter Brett McKay at the Investigative Journalism Foundation obtained internal documents showing that existing voluntary addiction treatment and detox sites in Edmonton were considered as interim locations for the province's involuntary treatment program. The documents identify the Henwood Treatment Center and the Addiction Recovery Center as possible sites, even as voluntary beds remain scarce. Alberta's Compassionate Intervention Act allows police to apprehend individuals whose addiction or substance use is determined to be a danger to themselves or others and held for detox and medical assessment. Persons detained under the Act could be held at a government treatment facility for up to 3 months, sent to community-based addiction programs, or discharged. The access problem is equally significant. Public reporting of addiction treatment wait times stopped in 2020, and Recovery Alberta told the IJF that the measure is not officially tracked. Without consistent wait time and capacity data, the public cannot determine whether involuntary treatment is adding resources or merely reallocating already limited voluntary services. In British Columbia, LGI reporter Michelle Gamage at the Tyee spent a year trying to learn how many patients overdose while inside provincial hospitals, but after a final appeal, the data is in. After 8 Freedom of Information requests and 2 appeals, only Fraser Health provided their requested data. It recorded 6,280 non-fatal unregulated drug events across 12 hospitals between 2020 and 2025. Other health authorities offered conflicting explanations. That data was not tracked, could not be extracted without unreasonable work, was protected inside patient safety systems, or could not be released because of privacy concerns. Island Health and Northern Health did not provide formal responses. Provincial Health Officer Dr. Bonnie Henry previously told the Tyee it is difficult to track what happens to patients in hospitals and that the health authorities had not been directed to track when patients overdosed on illicit, unregulated drugs while under hospital care, which did not sit well with some doctors. The result is a major gap in public health accountability. Privacy protections are essential, but aggregate data can often be designed to protect individuals while still allowing the public to understand the scale and location of a systemic problem. In Nunavut, LGI reporter Artie Sarkisian at Nunatsiaq News used access to information law to obtain an incident report about a New Year's Day death in an Iqaluit correctional facility. The report is heavily redacted but confirms an RCMP investigation, an internal workplace review, and a mandatory coroner's inquest. A separate corrections action plan lists staffing shortages, inadequate training, and outdated policies among the visible operational concerns. The Justice Department's Director of Policy and Planning stated the government made no public statements about the incident to, quote, protect the privacy of those involved and to preserve the integrity of the ongoing investigations, end quote. The Office of the Chief Coroner didn't respond to a request for comment, and Nunavut RCMP declined to provide further details. The case shows how access requests can establish basic facts when public reporting is otherwise limited. Next, LGI reporter Aloha Aloda at New Canadian Media examines how artificial intelligence is changing immigration fraud. Some lawyers have had their professional identities stolen by fraudsters so they can prey on potential vulnerable victims. While not all cases involve AI, Emerging AI tools are making long-standing immigration fraud schemes increasingly convincing. Immigration officials acknowledge that generative AI is being used both to prepare legitimate applications and to create fraudulent material. Immigration, Refugees, and Citizenship Canada declined to describe these specific techniques, warning that publicly disclosing operational details could inadvertently help bad faith actors evade detection. IRCC also uses AI and advanced analytics for triage, summaries, and client service tools, while saying final decisions remain with human officers. The accountability challenges is two-sided. Regulators must identify increasingly convincing fraud, while being transparent about how their own automated systems affect applicants. Finally, in the Access Roundup, federal public servants began returning to offices 4 days a week, although several departments say they do not yet have enough space. Even so, public bodies are trying to adhere to the policy despite the lack of space. Documents obtained through access to information estimate that reducing federal office space could save between $19 and $39 billion over 10 years, depending on the scale of the reduction. The government says in-person work will improve service, while unions say the policy lacks evidence and conflicts with earlier plans to shrink the federal real estate footprint. They also argue the return to office order is a handout to 4 banks to protect their roughly $10 billion worth of commercial real estate office exposure. The records give the public a basis to compare those competing claims. And now to Canadian privacy. In New Brunswick, LGI reporter Connor Barry at the River Valley Sun reports that patients may face fees to obtain medical records after a doctor retires. Some practices transfer files to private records management companies, which then charge for copies or transfers. Provincial law protects confidentiality and a patient's right of access, but for people who suddenly lose a family doctor, a substantial fee can make that right difficult to exercise. RSRS, an Ontario-based records management company in New Brunswick, said on their website it will never make the fee for medical record copies a barrier to receiving the file, and the fees are non-prohibitive. The policy question is whether continuity of care should depend on a patient's ability to pay for records created in the course of publicly funded health care. In Alberta, country musician Corb Lund is considering a judicial review after Elections Alberta rejected his citizen initiative petition on coal mining. His group submitted more than 207,000 signatures, but statistical verification reduced the estimated valid total below the required threshold. Among the 207,000, Elections Alberta counted 196,000 valid signatures. The agency said when it did random checks on the authenticity of names, statistical sampling led them to estimate 172,000 were verified, causing the petition to fail. Lund questioned verification calls that asked people to confirm names and addresses from unfamiliar numbers. Elections Alberta says advanced texts were sent, and signatures were not rejected simply because someone failed to answer. The dispute highlights a difficult privacy design problem. Verification must be rigorous, but the process must also be recognizable and trustworthy enough that people will safely respond. In addition, FIPA would love to hear from statisticians and democratic experts about the ethical implications of employing statistical analysis to infer and extrapolate identity verification in a democratic process where one signature is meant to reflect one voter, and who gets to put a potential thumb on the scale. In Ontario, newly released court records add detail to Project South, a major police corruption investigation. 7 Toronto police officers and a retired constable are among those charged in a case involving allegations that personal information was accessed and leaked to organized crime figures. Many allegations remain untested, and large portions of the records are still redacted or subject to publication restrictions. The Canadian press and other media outlets are contesting the publication ban and extensive ITO redactions in court. An Ontario Superior Court judge lifted the ban on some information on Friday. The core privacy concern is the potential misuse of privileged law enforcement databases. Systems built for public safety can create severe risks when access controls, auditing, and accountability fail. And in a similar vein, Pincher Creek, Alberta, LGI reporter Samia Loya at Shoot in the Breeze reports on Community Connect, a voluntary service allowing residents and businesses to share emergency information with first responders. Users can provide mobility needs, pet information, access codes, emergency contacts, and property details. Officials say the information is stored in Canada, encrypted, and available only during a response to the registered address. The emergency services chief claimed the information is stored at the same level as banking information. When a 911 call is made, dispatch captures the caller's address, which is cross-referenced with the Community Connect database. If the address has a registered profile, the information automatically appears on responders' devices. The program may improve emergency response, but its success will depend on clear consent, strict access logging, limited retention, and regular reminders for people to update or delete outdated information. And now we have a brief segment on Canadian cybercrime. Mount Royal University in Calgary is investigating a cyber attack affecting students and employees. The university says some data was taken and deleted, while other departmental information was deleted without ever being accessed. The university indicates full recovery may not be possible. Some affected people are being offered credit monitoring and identity theft protection, and the incident has been reported to police and Alberta's Information and Privacy Commissioner. The case is another reminder that the response to breaches must address both exposure of personal information and the operational damage caused by destroyed records. Meanwhile, LGI reporter Sandy Krasowski at the Chronicle Journal reports that scammers impersonated the Canadian Lakehead exhibition to solicit vendors. Fraudulent messages ask businesses to complete application forms, provide personal and commercial information, and pay to reserve space. Police and organizers say vendors should use only the exhibition's official office, phone number, or email address. The fraudsters have been using the email address CanadianLakeheadVendors@gmail.com rather than the organization's official email address. For organizations, consistent public contact information and rapid warnings are basic but important safeguards against brand impersonation and data theft. And now we shift to south of the border. In the United States, lawmakers, courts, and advocates are again confronting the harms associated with social media platforms used by children. New litigation has focused on platform design choices rather than user-posted content, opening another route around the broad liability protections of Section 230. The Senate Judiciary Committee has invited the CEOs of Meta, Alphabet, TikTok, and Snap to testify at an upcoming hearing about children's safety on their platforms. Congress is considering a bipartisan child safety package, but advocates argue it lacks a meaningful duty requiring companies to take reasonable steps to prevent foreseeable harm. Critics say that without duty of care, big tech companies will maintain the status quo of putting profit before the safety of children. The larger issue is whether privacy settings and parental controls are enough when the underlying business model still rewards prolonged engagement and extensive data collection. Election administration is also becoming a major privacy battleground. Courts have blocked several Trump administration efforts to centralize voter information, impose new registration requirements by executive order, and use federal systems for large-scale citizenship checks. On the other hand, Republican-run states have largely satisfied his demands to redraw congressional district lines, as he has been directing his Department of Justice to investigate voting and election operations. One federal judge has found that aggregating sensitive personal data could lead to eligible voters being wrongly removed. The constitutional point is that election rules are principally set by states and Congress. The privacy point is that data matching at national scale can amplify errors and put voting rights at risk. That concern became more concrete in New York, where federal officers confronted a poll worker about social media posts criticizing an immigration officer. Homeland Security says the worker had published an officer's address. The worker and civil liberties advocates say protected speech is being targeted. The post the worker made is still up, and she said she had no intention of taking it down. She also said she would be using this experience to defend and support First Amendment rights. Homeland Security considered the post, quote, doxing. The encounter did not disrupt voting, but bringing federal officers into a polling place to address online expression creates an obvious risk of intimidation, even when the timing is described as incidental. In Wisconsin, the state Supreme Court refused to release guardianship records sought by an activist who wanted to compare people found ineligible to vote against the voter list. The majority concluded that the records were not public under state law. The guardianship order is granted by a court, giving a person certain legal rights over another who is determined to be unable to make decisions about their life. A court has the power to remove the right to vote from a person under a guardianship order if the person is determined to be unable to understand the objective of the election process. The ruling protects sensitive information about vulnerable individuals, but it also illustrates the recurring tension between election transparency and privacy. Effective oversight does not always require publishing names and addresses, and carefully designed audits can test the accuracy of voter rolls without exposing personal court records. Surveillance practices are also expanding through legal loopholes. A VT Digger investigation found that Vermont police, despite strict state limits on automated license plate readers, conducted more than 100 out-of-state plate searches through a regional intelligence network. This is taking advantage of a loophole in a state law that was adopted more than a decade ago. It never included the use of a national network of cameras, which didn't exist at the time, to track license plates of people when they travel out of state. The searches relied on a national network of more than 80,000 cameras. Police say the system helps investigate serious crimes. Critics note that the network operates largely outside public view and can reveal movements far beyond the original jurisdiction. A privacy law that regulates only locally owned cameras may be ineffective when agencies can obtain the same data through another state or a private intermediary. Mississippi is taking a different form of data collection even further. A new law authorizes the State Department of Public Safety to compile names, addresses, countries of origin, ages, criminal histories, and the deportation information for people believed to be living in the state without legal status. The department is directed to share information on those suspected of violating laws with state and local authorities. The measure neither requires nor prohibits the database from being shared with U.S. Immigration and Customs Enforcement. Supporters call it a way to measure and address illegal immigration. Opponents warn that it invites profiling, will be difficult to keep accurate, and may discourage residents from contacting police. Lists built around a person's status can quickly become tools for enforcement beyond their stated purpose. And a Freedom of Information Act lawsuit is seeking the Pentagon's agreement with Scouting America. The Pentagon made a deal with Scouting America in February that Defense Secretary Pete Hegseth said would refocus the organization away from diversity initiatives and other, quote, woke policies. Hegseth threatened to cease the military's longtime support of the organization if it failed to comply in 6 months, which would be in late August. Hegseth said the organization agreed to policy changes concerning transgender members, while Scouting America says its existing inclusive policy remains in place. The government has not released the memorandum, has not given an exemption, and has missed every deadline. Whatever the underlying policy dispute, the access issue is straightforward. When a federal department claims a private organization has accepted conditions in exchange for government support, the public should be able to see the agreement and evaluate what was actually promised. Now to international stories. Along the United States-Mexico border, the Trump administration is spending $46 billion on what it calls a smart wall, physical barriers combined with cameras, sensors, autonomous towers, artificial intelligence, and underground fiber optic detection. One nonprofit that focuses on civil liberties related to digital technology has published a guide on the various types of surveillance towers in use along the southern border designed to help local residents. Officials say the technology lets agents cover more territory, Border residents and civil liberties groups say surveillance equipment has appeared near and sometimes on private property while crossings are at historically low levels. It was also said that surveillance technologies can push migrants into more dangerous routes to avoid being detected. The essential question is not whether the system works, but how far border surveillance reaches into the daily lives of people who live nowhere near a suspected crossing. In Turkey, journalism groups say several independent and opposition-aligned outlets were denied accreditation for a NATO summit in Ankara without reasons or an appeal process. NATO says host countries assess domestic media applications, but also say in-person media access is important. Turkish officials haven't commented on the accreditation issue. Excluding selected outlets from a major international meeting restricts the public's ability to receive independent reporting and allows governments to shape which questions are asked inside the room. Turkey is also implementing wide-ranging precautions in the lead-up to the summit. Earlier this week, security forces detained more than 200 people suspected of links to extremist groups, the Ankara Chief Prosecutor's Office said. But opposition parties and media reports said that a politician, an academic, a journalist, and prominent LGBTQ activist and lawyers were among those detained. The most serious access story this week comes from Germany. The transparency organization Frag den Staat says the governing coalition is planning changes that would effectively dismantle the Federal Freedom of Information Act. The reported proposals would require requesters to prove a legitimate interest, a specific right to the information, exclude organizations and many non-citizens, broadly redact officials' names, remove the current fee cap, and add more grounds for refusal. Proof of citizenship would also be required to submit a request. Germany's law has existed for 20 years and has been used by journalists and civil society groups to expose misconduct and test government decisions. More than 100 organizations and media outlets have signed an open letter opposing the plan. The government has not yet enacted these changes, but the direction is a warning familiar in many jurisdictions. Access rights can be weakened not only by repealing a statute, but by adding eligibility rules, costs, exemptions, and procedural burdens until the right becomes unusable. And in South Korea, the government is disputing a U.S. congressional report that accuses it of discriminating against the American-listed e-commerce company Coupang. South Korea's privacy regulator imposed a record 625 billion won fine, roughly $403 million US dollars, after a breach exposed information connected to more than 37 million people. Authorities say the company failed to report within the required 72 hours and that basic security failures allowed a former employee continued access. South Korea's Personal Information Protection Commission said the personal information of more than 37 million people had been exposed, including 33 million Coupang customers. Coupang says it will challenge the fine, accusing the privacy regulator of failing to properly consider the company's efforts to strengthen safeguards and prevent further harm. The international dispute shows how privacy enforcement against a multinational company can quickly become entangled with trade, lobbying, and diplomatic pressure. Before we go, an Associated Press and Frontline investigation examines how trafficking compounds in Myanmar use American artificial intelligence models, cloud infrastructure, internet providers, and satellite connections to run scams at industrial scale. One trafficked worker said software helped him manage more than 100 conversations at once and target tens of thousands of people across multiple languages. The investigation found no evidence that the technology companies were themselves committing crimes, but it raises a difficult accountability question. When providers can't identify persistent patterns of fraud and abuse, what obligations should they have to disrupt them? Regulators in the United Kingdom, European Union, Australia, and Singapore are beginning to impose stronger duties. In the United States, much of the response still depends on voluntary cooperation. As always, we hope today's stories help you stay informed about the latest issues in privacy, information management, and public transparency. Please subscribe wherever you listen and consider supporting FIPA through a donation or a FIPA News monitoring subscription. Your support helps us continue producing independent research, public education, and this weekly program. Our writer is Sean Fisk. Original music in today's show was composed by the mysterious Breakmaster Cylinder. I'm Patrick Farnsworth, your host and producer. Thank you so much to the reporters, contributors, and outlets whose work make this podcast possible, and thank you for listening. Stay safe and stay informed.